and the reporter.
Your Honor, if I may, first I do have one additional argument regarding necessity, but also Travis Colby will be stepping in as my co-counsel, and he will be arriving here around 2:30.
Okay, well, we can't wait until 2:30.
Understood.
Yeah.
If I may be briefly heard on necessity before you announce your ruling.
Okay, three-call argument, we gotta wrap
Yes.
up. Yeah.
Addressing if the health emergency would be health concerns regarding the chicken ending up as human food, I do not believe it constitutes an emergency because it relies on multiple levels of speculation. That one, the chickens were sick. Two, the chickens were sick with a disease that could harm a human. Three, that Foster Farms screening process would not catch these chickens and pose a human and health hazard. Four, that the chicken would be slaughtered and turned into some food consumable by humans. Five, that it would end up on a store shelf or in a restaurant. On six, that it would end up being consumed rather than ending up being thrown away. And then finally seven, that it would in fact make someone sick. Due to this is not a immediate emergency, but a speculative emergency that the defendants that relies on multiple levels of speculation on the defendants at the time I'm taking of the chickens, even by the events presented by the defendant, defense.
All right. Mr. Carey, you
Just
want to
briefly,
respond?
that's a great closing argument, based on factual assertions, and that's why this should be a jury question. And it's a factual dispute. It's not particularly relevant to sort of the legal lower threshold. I think that's an argument that the prosecution certainly can make to the jury, but in terms of the lower threshold for the criminal defense, it's irrelevant.
Okay.
You know, I would just add, the proof that we're planning to offer is not speculative. It's very, very clear from veterinary records that these chickens had diseases that could infect and endanger the human population. Mm-hmm. And nothing in the necessity instruction indicates that risk of significant evil isn't sufficient. In other words, say you have a bomb that may go off or may not go off. Trying to stop that bomb from going off, even if you're not 100% sure the bomb is going to go off, is a sort of harm that you're allowed to try and avert with the necessity of defense. These defendants obviously could not have been sure this chicken would have been consumed and killed a child in a hospital in Merced County, but the risk of harm is sufficient under necessity to allow at least introduction of evidence. It's up to the jury to decide whether it's sufficient evidence, but it is a factual question.
Okay. So, okay. All right. At this point, the court is going to deny defense motion to present the necessity of defense. I'm reading, counsel, I'm reading from your motion here, and the motion indicates, for example, factual background on item number 3, Ms. Santurio is a volunteer with the Animal Rights Group, direct action employer. She's conducted investigations in factory farms across the country, including at Foster Farms facilities. On September 28, 2021, Ms. Santurio was aware of repeated animal cruelty at Foster Farms. Specifically, in the weeks prior to the alleged offense, she was provided with hours of undercover footage showing animal cruelty, including live birds falling under a conveyor belt to be discarded, birds being improperly hung, birds not properly stunned before slaughter. These were later corroborated. Item 6, there were letters sent to a litany of government agencies regarding animal cruelty treatment by Foster Farms. Item 7, paragraph 7, direct action sent letters to prosecutors in Merced County regarding these practices. No actions were taken. Item 8, they opened the gate to the transport truck, observed 2 chickens. Ms. Santurio had a substantial experience raising and rehabilitating injured chickens saw one chicken that was down and had splayed legs. Okay, she concluded the chicken was injured and needed immediate medical care. Number 10, Ms. Santurio knew that video footage had foster farms, that the bird would not get the care unless she acted. That the bird, number 11, the bird will continue to needlessly suffer, okay, and so on and so forth. In your motion, there was nothing discussed about public health, about her action motivated to protect public health. I'm reading from element number 1 of 30 Code 3403 requires it has to be defense of the person or someone else. And so the court does not believe, based on what you intention to introduce here, that the defense applies. Okay, so the motion is denied. Okay, let's go next item.
And just for the record, that is related to people's 5 and 6.
Okay.
So,
5 to 6, people's 5 and 6 are granted then?
yeah,
Okay.
thank you, Your Honor.
Next item, Mr. Carroll.
Yes. Well, just first with respect to that motion, just to clarify the record, we made that request pursuant to Ms. Santurio's state and federal due process rights, rights to present a defense, and rights to effective assistance of counsel. I think the next affirmative defense, and these two really sort of work in tangent, is the mistake of law affirmative defense as well as claim of right.
Right.
Those, and that relates to people's motions 3 and 4.
Good.
So for both motions, the factual background is that both Ms. Santurio and Ms. Paul volunteer with the animal rights advocacy group Direct Action Everywhere. In 2018, the group solicited a legal opinion from UC Hastings law professor Hadar Avaram on the applicability of the necessity defense in the context of coming across animals showing acute animal suffering. Both Ms. Santurio and Ms. Paul were very familiar with that letter, had read that letter before the date of offense, and certainly will provide evidence that that legal opinion was their background for their belief in the lawfulness of their conduct and their intent. So I think first, mistake of law, the really controlling case would be People v. Weinberg, 125 Cal App, 3rd, 127. There, the court recognized that a honest, good faith belief in the legal right to take property would be a valid defense to theft. Additionally, People v. Koenig, 58 Cal App 5th, 771, indicated that reliance on the advice of counsel is one way that a mistake of law can negate the intent for a specific intent crime. And the inquiry there is not whether that advice was correct, it was whether the defendants had a good faith belief, because that's specifically tied to the specific intent nature of the offense. Similarly, claim of right indicates it applies also to theft offenses. That's People v. Fenderson, 188 Cal App 4th, 625, and People v. Tafunga, 987 Pacific 2nd, 168. The court stated the claim of right defense provides that a defendant's good faith belief, even if mistakenly held, that he has a right or claim to the property he takes from another negates the felonious intent necessary for conviction of theft or robbery. And so I think those principles are fairly analogous, similar for either defense. But what the court should take away from that is our offer of proof certainly is that both Ms. Santurio and Ms. Paul relied on a legal opinion that the group they worked with had procured that applied to this factual sort of scenario, and that related to their specific intent here. So I think under that standard, the jury should be tasked with determining whether or not that was a good faith belief, and we posit that it was a good faith belief based on the credentials of who was giving that opinion.
Okay, yeah, I think you're mixing, you have a couple of motions here, you have the claim of right as well as you have the mistake of law, right?
Yeah,
And you're saying both of those, both of those are sort of related in the sense that the mistake of law is that they believe they have a claim of right here?
so the mistake of law essentially turns on the fact that they relied on advice of an attorney that said under similar factual scenarios such as the ones that they came upon, that necessity would essentially absolve them of their conduct to do rescue. And I think that's an important criteria here if the court is going to sort of limit the necessity defense based on the jury instruction to only people. Because this, I think, more directly goes to their state of mind, their specific intent, and really that's what Weinberg and similar cases are focusing on. If this were a general intent crime, we wouldn't be having this conversation. But since this is specific intent, it sort of broadens what the jury can consider in terms of what was in these defendants' minds. So I do think the standard for both are fairly similar.
Well, I think mistake of fact may be a defense, but mistake of law is not a defense.
And I think mistake of law is a defense, and I think that's found in Weinberg.
Well, Cochran 3407 is pretty specific. Mistake of law is not a defense. So even if they had a good faith that their conduct was lawful, it's not a defense.
Your Honor, if I could just add, I think the way to reconcile Weinberg with the Calcrum instruction is that really mistake of law is not so much a defense as the absence of an element of the offense charged against the defendants. Namely, because theft is a specific intent crime, and because under the Calcrum instruction on specific intent, the intent to commit the prohibited act is required to be proven beyond reasonable doubt. Under Calcrum 1800, the intent to permanently deprive an owner of their property is required by the prosecution to prove beyond reasonable doubt. It's not so much that mistake of law is a defense. It's sort of like a situation where I see a wallet on a table and I think I'm entitled to take it because, for example, maybe that person owed me $100 and it's their wallet, but I really genuinely just believe that because the person owed me $100, I took the wallet to get my $100 back. And I might be wrong about the law, but I didn't have the intent to commit a prohibited act or the intent to deprive someone of their property. I thought I was entitled to take that money back. Or another situation would be a mechanic's lien. So say if someone repaired your car and you didn't pay them, and they consulted with an attorney, and the attorney said, yeah, you can just go take the car back. Because you repaired the car, they owe you $1,000, just take the car back. Even if your attorney gave you bad advice about whether you're allowed to just take that car back from the person you had a mechanic's lien on, it would be a defense of theft because you lacked the criminal intent. The intent of these two defendants was clearly not to do anything wrong for a lawful. It was to aid a suffering animal. That is not the sort of criminal intent envisioned by the Calcrum instructions on theft and specific intent. And so one way to think about mistake of law and advice of counsel is not so much that it's an affirmative defense, but we're entitled to introduce this evidence because it reflects the state of mind of the defendants, which was not to engage in a criminal, unlawful, or wrongful conduct, but rather just aid an animal pursuant to advice they'd received from an attorney, which is more similar to a situation where you're taking a wallet back improperly, but you don't realize it, or you're even taking a car back, something as expensive as a car. If a mechanic goes and just says, I'm going to take self-help and take that car back because I'm entitled to the cost of the car, that is not theft. It might be conversion, it might be civil tort, but because the person lacks the mental state required for a theft, we're entitled to present evidence as to their mental state, which was not to engage in a lawful act, not to commit a theft, not to do anything unlawful at all. But pursuant to the advice they got from the lawyer, it was simply to give these animals aid who were suffering egregiously on the floor of a slaughterhouse truck.
Hold on a second. Is this a specific intent crime, Mr. Atwell?
Yes, Your Honor.
Okay.
I would point the court towards.
So if it is a mistake, it is a specific intent crime, then would you agree, Mr. Atwell, that instruction 3411 would apply? 3411, if you read, that's mistake of law as a defense to specific intent crimes.
Yes, however, in People versus Menez, as the court...
What's that site, please?
People v. Menez, 2008, 165 cal.app.4 1648 1661. held that generally a mistake of law is extremely rare when that is a applicable defense, and usually when it's a failure to act rather than affirm the defense. And also in the cases cited by the defense, People v. Vinberg and Diesel v. Koenig, the defendants were given direct advice by counsel at or near the time of the action of the actions that led to their being charged with crime, and in both cases, the instruction on mistake of law was ultimately denied by the court. But in this case, the advice given was not a direct advice of counsel, but a letter from 2018. The incident here was from 2021, and it's unreasonable for someone to form a good faith belief that their actions are lawful. Also, that letter applied to a factually different scenario. It applied described a situation in a facility, in a slaughterhouse, and a direct observation, and not on a street from a truck. So expanding that letter and allowing the defendant to apply that defense would be allowing them to use advice to a third party who's not on a defendant in this action from 2018 to defend an action in a factually different situation in 2021 to what the letter described.
What do you want to exclude? You want to exclude that letter?
Exclude the letter and the defense as inapplicable law.
Okay. Mr. Caraway, what was the basis of the legal advice? Can you present an offer of proof?
Yeah, Judge, we filed that letter with the court yesterday.
Okay, you did.
But, I mean, I think that's why the legislature has that good faith component. Because certainly the prosecution can argue whatever time frame or anything like that negates that good faith. But, quite frankly, the legal opinion regarding necessity defense, it's titled Legal Opinion Regarding Necessity Defense in California Penal Code 597E in the context of open rescue of animals. So it is not a factually specific advice to something in 2018. It's just the applicability of the common law doctrine of necessity as it applied in situations where you come upon animal suffering. And certainly the defendants had an honest, good faith belief that that information that was given to the group they work with, it's no different than if of counsel provides legal advice to a corporation and its agents rely on that. It's the same impugning that knowledge, but these are instances in which they had direct knowledge, they relied on that letter, and that was their sincere, honest belief. I mean, again, it's a specific intent crime. The court has a sua sponte duty when there's substantial evidence or when there's evidence that they were relying on a mistake of law. To the extent we don't even need to ask for it, but I certainly think that there's enough evidence here where the question of good faith, that's a jury question, and that the jury should resolve that. And I think consistent with our rights to present a defense under both constitutions, so we should present that evidence as it relates to Ms. Santurio and Ms. Paul's state of mind and intent. Thank you.
Your Honor, just to supplement the offer of proof, the letter mentions very explicitly not just a specific factory farm, but factory farms in other animal processing facilities. So, for example, it says that open rescuers move animals from factory farms and other animal processing facilities because they genuinely believe that their actions are necessary to protect these animals from harm. So the advice given by this letter applies not just to the specific scenario described in the letter, but factory farms and other animal processing facilities. And I don't think there's any doubt that the Foster Farms facility in Livingston, California is an animal processing facility. So this is ultimately a jury question, the question of good faith, the question of whether the time difference between 2018 and 2021 is relevant to determination of good faith is a jury question, is a factual question. And if you look at the instruction yourself, and I thank you for pointing me to the instruction, Your Honor, But the instruction does not say that you have to receive advice of counsel within a certain period of time. It does not say you have to receive advice of counsel within, on a very specific factual scenario that is consulted with an attorney. All it says is you have an honest and good faith mistake about the law. The limited circumstances under which a mistake of law defense is appropriate are the circumstances of this case, namely where we have a specific intent offense, where the state has a burden to prove beyond a reasonable doubt. And it's really not entirely accurate to even say this is an affirmative defense, because as the instruction indicates, they have the burden to prove this beyond a reasonable doubt. And if we can inject doubt about whether they had a good faith belief about the lawfulness of their actions, that is sufficient. So it's not so much that we have the burden to prove by preponderance of the evidence that the mistake of law defense applies. They have the burden to prove that my client had criminal intent. The fact that she had a legal letter from a very distinguished criminal law scholar applying to this particular scenario is evidence that she did not have the criminal intent that the state has a burden of proof.
All right, submit it.
If my certified law clerk may have a moment.
Okay.
In the instruction itself, it does say that the defense is available when the defendant did not know they were breaking the law. In this case, their argument is not that they didn't know they were breaking the law, it's that they had an available defense to breaking the law. So I don't believe that that is entirely appropriate. The defense of mistake of law is that they thought their action was in fact lawful, not that they had some sort of defense to an unlawful act.
Okay. Is there a distinction? In other words, if they believed that what they did was either defensible, what they did was lawful because they relied on that, I guess in a legal mind, there might be a distinction, but in terms of the person who actually was not a legal trained mind, said, I believe what I did is lawful, whether it's a defense or whether it negates one of the elements. Is there a difference? I mean, for us, perhaps it makes a difference, but for the person who testifies and say, hey, I relied on this document and said I can do this, it's perfectly all right. What difference does it make?
It may be slightly splitting hairs, but they're still not saying, I believed what I did was lawful.
Yeah.
Just that I could do it and escape punishment, which is that I would have an excuse after the fact, which is still a different claim.
Sure, and that would be, I think that would be.
A little onto necessity.
Sure, and I agree that would be probably a jury question to determine whether the person really knew what they did was lawful, or they knew what they did was unlawful, but they can get away with it. Mm-hmm. Right.
Also, if I may, Your Honor, or allowing this defense would allow anyone with any specific intent crime to rely on some letter to some third party given at some unknown point. It has been established by the defense counsel exactly how the defendant became aware of this letter, or how many levels of hearsay are between this letter and being issued to direct action everywhere, and then finally being made aware to the defendants.
Well, at this point, the court's going to allow arguments to be made regarding the defense. What evidence comes into the defense remains subject to you raising an objection in the courtroom, and the objection. Some of the evidence might be inable hearsay. So just because the court allows evidence to be introduced regarding defense, that doesn't mean that all evidence comes in.
Although if I'm, again, and if, like, I could get a letter or from a attorney saying that.
I'm not saying the letter can come in. I'm just saying that if the evidence comes in and there's such a letter and you raise a proper objection, if the objection is sustained to that letter as inadmissible, then the letter is inadmissible.
All right. Okay, at this time then I'd be arguing that the letter is inadmissible because it's hearsay, a unknown multiple levels of hearsay.
Okay. Well, we can raise that issue if it is introduced. I don't know if it will be introduced. It's premature at this point. Yeah. So that would be, I'm not sure how we would work this, but I say with regard to defense motions eliminate to regarding mistake of law, that the court will permit evidence to be introduced as subject to any objections to be raised regarding subject to any other objections of hearsay or foundations. Evidentiary objections, I would say. Okay. Okay, next item.
Judge, I think we already resolved the value during this day, so I
I
would.
also, we haven't resolved the claim of rights
Oh,
that we were
All right,
arguing.
okay,
And Judge, I would just submit effectively the same argument.
okay.
It's the same evidence, so I think the court can sort of reserve that based on the evidence that actually comes out during jury instructions conference.
And I would just join in that argument for both motions, Your Honor.
If I understand the argument, the argument is that the defense claimed they have some legal interest or some proprietary interest in the chicken because of them, they were so advised by this letter or they had received some letter. Is that the gist of the argument?
Yeah, the gist of the argument is, I think, twofold. Is one, that they believed that they had the legal right to rescue and take possession of the animals. And again, the standard's not whether they were actually correct, it's whether they had a good faith belief. And I think there's also an argument that based on the neglect that Foster Farms had provided the chickens, that it was effective abandonment. The arguments fairly collapse into one another, but the standards are relatively the same. It's good faith belief to negate subjective intent, which this crime is.
Okay, yeah, so it goes to the issue of specific intent. Mr. Atwell, is there a reason why this should be treated differently?
One, the defense is not provided, again, this is conflating a mistake of law. No, for the first part that this is conflating mistake of law with claim of rights. That it was necessary, they saying that the defendants had a mental state that it was necessary to take these chickens, but that distinct that defendants believed that they had a title or claim in specifically to these chickens. That is what claim of right is about. They also are articulating that the chickens are treated so poorly that that the chickens are trash. However, again, that is not a belief that argument that the chickens are somehow belong to the defendants, that merely that Foster Farms is not treating these chickens up to the defendant's subjective standards. If this defense, it would be like me hooking up one of the various vehicles left on people's yards to rot and driving away with it because they are being treated as trash. I don't have a good faith belief that the owner has some way relinquished their claim of ownership, but that this car is not being treated as well as it should be. All
right. Well, I think the defense, correct me if I'm mistaken, the defense wants a jury instruction regarding claim of right, right?
Yeah, it is our intention that we believe the evidence presented would justify both instructions for mistake of law and claim of right. On similar evidence, there are some distinctions there, particularly the abandonment argument unique to claim of right. But I would also note that the jury instruction is broader than most in terms of the reasonableness, because it states that if the defendant was aware of facts that made the belief completely unreasonable, you may conclude the belief was not held in good faith. So I think in terms of, especially compared to necessity, where the question of reasonableness isn't as squarely put to the jury, here it's contemplated that the jury can certainly determine whether unreasonableness of an opinion negates that good faith. And I think that supports the argument the jury is tasked with determining that sort of threshold question. So I think just based on that similarity of the defenses, we would submit.
Good.
Your Honor, I would just add additionally that claim of right is a statutory defense as opposed to the lack of an element. So the distinction is not an important one, but we just thought that additional instruction should be included based on the statutory language that allows the defendant to ask for this instruction and this particular language to be presented to a jury before they render a verdict of guilty or not guilty. I would also just add on to the abandonment argument, I raised this with Commissioner Foster previously, that the appropriateness of that instruction, I agree with the prosecution, there has to be some claim of title. It can't just be right to possession, it has to be a claim of title. And there is case law in the state of California which indicating, and this is a non-district versus self-realization versus Massachusetts Bay Insurance Company, 95 Calap 4th, 1273, items, quote, which have been placed in an outdoor trash barrel no longer retain their character as the personal property of the one who has discarded it. By placing them into the garbage, the owner renounces key incidents ownership, title, possession, and the right control. That includes title. So I think it would be appropriate for Your Honor to make an instruction on this after the development of evidence at trial. I think we will present abundant evidence that these animals were effectively treated like garbage. They had been effectively abandoned by foster farms by virtue of the fact that they were starving to death, unable to walk, and so sick they could hardly even move and had not been given any sort of veterinary care. It is then up to the jury to determine whether that effectively has led to a reasonable inference that title over these animals has been relinquished, and some other passerby who saw them could pick them up. In the same way that if I saw someone throw a piece of lint on the ground, I might say, okay, that piece of lint clearly is not something Alexandra wants because she's thrown it on the ground. I think it's a factual conclusion for the jury to make. And so, but I also think that it would be appropriate for Your Honor to make a ruling on the instruction after the close of evidence and a determination of whether we have presented substantial evidence for the defense.
Your Honor, if I may, in the offer of proof, they conceded that the defendants took the chickens from a truck, off a truck from Frost Farms. They aren't saying that the chicken was left on the side of the road, thrown into a trash bin, or left abandoned for days, weeks, or months, but they actually took it. Again, I'm not disputing that the defendants thought that they may had a good faith belief that the chickens were ill-treated, but that's not the same thing as abandonment. That the property that they had a good faith belief that it has been relinquished is by Foster Farms. I'm saying again, it would be, if this defense is allowed, people could start pulling off rusted or otherwise ill-treated property from people's yards. Right. And again, there's no claim that they had a claim of specific title or otherwise. So claim of right, it does not apply even under the defense's offer of proof.
Well, I think this is going to be a jury question here. The court's going to reserve judgment until the evidence comes in to rule on this issue. Next item.
I think we're now passing to your motion.
Yeah, Your Honor, I think the next motion that is still not completely resolved is, it's kind of a combination of the motion on value, which I think was granted, and we discussed it earlier, but also the motion to compel, because we did file a motion to compel on February 3rd, asking for the prosecution to give evidence related to the property at issue in this case, in particular its value. That motion was granted. Subsequent to that motion, we also had a hearing with you where we discussed the same issue with Foster Farms. The motion for subpoena induces tecum to provide documents was also granted. And the main issue we're facing right now is not just non-compliance with the motion to compel. That motion to compel was granted on February 21st. At the time, in the hearing, the prosecution indicated to us there are no more responsive documents they would be providing. But this has really gone back as far as December, many months ago, where the prosecution has repeatedly indicated to us there are no witness statements, there are no documents, no audio recordings, no reports about value. beyond a statement from one witness, the regional security supervisor at Foster Farms, Jaime Jimenez, alleging that the chickens were worth $20 based on the fact that they were live chickens in a slaughter truck, and that would be it. And I quote chapter and verse, I cite all the different exhibits of the times where I made the request informally. We filed the motion to compel. We begged and pleaded. We went to Foster Farms itself and filed a subpoena ducis tecum because I thought it was very likely that we'd be alleging something beyond just one witness's testimony that's a live animal worth $20. That's it. That's all they said they were going to provide us. And then just a couple days ago, on March 5th, we get an email, or March 2nd, I should say, we get an email saying there's initial audio recording. We can't provide it to you electronically, so we'll send it to you physically. We just received the CD-ROM of this audio recording yesterday night. A new report filed, I think on March 1st, indicating that the witness would not actually be Jaime Jimenez. It would be an expert witness, an expert in accounting and operational strategic accountant at Foster Farms, using completely alien terminology, documents and charts that are completely unintelligible to us and that we have not been able to review or even give to our expert at the very last stage of trial. And so I believe this is a violation of the court's order to compel documents on February 21st. Maybe more importantly, I think this is a violation of Penal Code 1054.1, which requires the prosecution to disclose, quote, written or recorded statements of witnesses within 30 days, or before 30 days of trial. And I think 1054.5 indicates the exclusion of witnesses and witness statements are appropriate when other remedies are inadequate. There are no remedies that are adequate at this stage when we haven't even, to this day, I have a CD-ROM that I'm not able to read. I don't even know exactly what's on it. Mr. Apple has attested to what he says is on it, but I still haven't even been able to read it because my laptop does not have a CD-ROM on it. And we are actually in the middle of the trial. So I could go into a lot more detail into all the emails and requests we've made starting on December 20th and literally at least probably a dozen or so times since then for this evidence. But respectfully, we moved this court to exclude all evidence of value disclosed at this late stage, especially a new expert witness on strategic accounting, a high-level executive at Foster Farms, disclosed at the 11th hour of trial. And beyond the statutory authority, I would also just cite...
Well, just to be more specific, you want to exclude evidence of economic value, but you're not moving to exclude. I don't think that would, your motion would justify excluding all evidence of value, including intrinsic value, would it?
It would only exclude evidence from Mr. Sutton and any late disclosed evidence or theory of value, because the theory of value the prosecution was asserting to us repeatedly through witness statements was we're going to have Jaime Jimenez testify based on the fact this is a live chicken and based on his experience as a security supervisor at Foster Farms, the chickens are worth $20. And that's what we went to our expert with. That's what we've been preparing our defense with. That's what they committed to do for us over the last 4 months.
Okay.
And literally 2 court days before trial, they have a completely new witness, a new expert, a new theory of value involving terminology like rendering credits, commendation credits, all this terminology we don't have time to prepare for because we are in the middle of trial right now. And I can't go back to my expert and say, look through these 30 charts that are completely unintelligible. Look through this audio file that I still haven't actually been able to play it myself. We're in the middle of trial and I have a CD-ROM that I cannot play. These are all violations of the prosecution's disclosure requirements, and I think an exclusion order is appropriate.
Aren't you going to have your own expert testifying as to economic value?
We have, but this was disclosed to the prosecution within the time frame, February 3rd. It was actually before 30 days.
But if you have your own testimony, wouldn't that open the door for rebuttal?
I think it would open the door for rebuttal if we were provided some evidence, real evidence, witness statements within the time frame that they would be providing rebuttal. But they haven't even indicated they're rebutting our witness. If they had provided us 30 days ahead of time, even noticed that, okay, we're going to call witnesses to rebut your theory of value, maybe there's an argument.
Okay. Mr. Atwell?
First, I did not possess as this evidence in 30 days prior to trial. Initially, I was not expecting value to be as large an issue as it has been in May, but in light of this, your ruling on February 21st, as well as Commissioner Foster's ruling in that value would be at issue, I sought out a witness from Foster Farms to testify in greater detail about value in light of the court's ruling 21st. First, I made
When did you do that?
I made the investigation request on February 23rd, but, the investigator who reached out on Foster Farms to get at the identity of a witness is present. I amended, before I knew the identity of the witness on February 26th, I amended my witness list as stating that I would be seeking in an expert, and I would provide that information as soon as I had it, and I had the name of the witness is as soon as I provided it. The audio recording was done on March 3rd, and I either March 2nd or March 3rd, or I only did.
It was the second, actually.
Yeah, sorry, March 2nd. So that recording did not exist. We attempted to provide that by email, and that did not work. And yesterday,
What is the recording, by the way? What's in the recording?
An interview by myself and one of my officer investigator of the witness is to make an offer of proof to the defense. And I've also provided the defense a summary of the informative investigation report of that that audio recording.
What's Mr. Sutton going to testify to?
That's testify how Foster Farms calculates the value of chickens, and additionally what happens to any chicken that is not found to be fit for human consumption, and that that any chicken that dies in the facility is rendered into its components of fat and other substances, which is sold for other purposes.
Okay.
Your Honor, if I could just clarify, what is problematic about that recording, which I don't even know if there are multiple recordings, there's one recording, I've heard part of one recording, is two things. One is, this is a vice president of accounting. Our expert is an animal welfare expert. We have not even talked to an accountant. And for us to prepare to properly cross or have an expert witness rebut an accountant, a senior accountant in Foster Farms, we have to go retain an accountant. That's going to take weeks, if not months. Secondly, the theory of value being generated is completely different from what they told us from day one. And I'll quote you now from the January 6th email Mr. Apple wrote to me. I will only be using Mr. Jimenez's testimony as well as the fact it was a live chicken belonging to a farming company to prove the point it has some market value. Subsequent email, the only evidence, and again, this is a quote from Mr. Apple's email to me after I battered him repeatedly because I didn't believe him at the time that this is all the evidence he was going to generate. The only evidence I plan to use gathering the chicken's worth is Mr. Jimenez's testimony. This shows they knew value was at issue. These are emails from early January after I sent them an email about this in December 20. They knew value was at issue. You could just look at the CalCrim instruction yourself. CalCrim 1800 says the property must have some intrinsic value, no matter how slight. So the idea that they had no notice that value would be an issue in this case until February 21st is incorrect. We've been talking about this, and they've been attesting to us that we're only going to have a lay witness, not an expert witness in accounting, but a lay witness who's a security supervisor testify for just a common understanding and knowledge perspective that the chickens were worth $20. We're now hearing there's an expert accountant saying there's a rendering credit system, a condemnation credit system from an accounting perspective that means the chickens are at least worth 3 cents. We have not prepared for this at all. I don't even know what this terminology means. I need to go talk to accountants, go talk to factory farming and accounting experts to try and rebut this evidence. And I think the only appropriate measure, and I think there's case law on this, in a situation like this, is exclusion of the witness.
Your Honor,
Sorry, you go ahead.
Your Honor, just to add to that, we requested expert discovery at the arraignment. We requested expert discovery in September. We've requested expert discovery in December when co-counsel came on board. Another thing that I think is worth knowing is that we were advised verbally today by the prosecution that they still don't know what Mr. Sutton is going to testify about.
Your Honor, if you only on specifically that about what happens to chickens that are dead on arrival, not chickens that were alive when they arrived at the facility. And there's, the people disclose that, but we do not believe it is relevant as the chickens are taken alive rather than dying, than any arriving dead on arrival.
And my additional point is, so we still don't have a definitive opinion about what exactly this witness is going to say. We are in trial. And furthermore, this is an accountant. Accountants, as the court well knows, they don't testify from their own innate personal knowledge. They testify based on documents, on the studies that they get from their clients, from information that they get from their clients. None of that has been produced in discovery. So we have a huge People versus Sanchez problem in this case because none of that information has been produced. So this witness, the intention is to have this witness come in and testify as to conclusions without ever providing the supporting documents. And that dovetails into the failure to provide the documents related to the subpoena.
Your Honor, those documents were in possession of Foster Farms. My office did not have possession of those documents until those documents were provided to both myself and defendant at the same time, and by email by Foster Farms in response to that, and to their subpoena. I did not request those documents. They were not in my file. Until again. Foster Farms responded to defense's subpoena requesting documents. So I would only be using documents presented by Foster Farms in response to defense's subpoena. Not any.
But Your Honor, in even the recorded statements you provided us, this witness was relying on those documents. And again, this is a Sanchez problem. This is case-specific information that would be inadmissible hearsay. And at a minimum, we get to see it. If he's going to rely on these documents to say the chickens are worth at least 3 cents per chicken, we have to be able to see these documents. And I take at your word, Mr. Atwell, that you didn't have these documents until February 21st. But that doesn't change the fact that we are at massive and severe tactical disadvantage in receiving these documents and a new expert with all this knowledge that Foster Farms has that we did not have until the start of trial. That is too late to disclose this evidence.
Your Honor, again, my office did not have these documents to disclose. These documents were in the possession of Foster Farms. If the defense again, under Penal Code 1054.5C, the court may prohibit the testimony of a witness pursuant to subdivision B only if all other sanctions have been exhausted. One of those sanctions being a continuance. And if the people have no objection if the defense believes for any continuance on the defense part are to review the documents provided by Foster Farms and my witness. However, again, and all other remedies must be exhausted before exclusion is.
Well, we're not going to continue the trial at this point. We've already impounded, we have the jury, not yet picked up, but we've selected the jury, so I'm not going to waste your time. But this is the court's ruling for the people's case in chief. Mr. Sutton's testimony is excluded. On the other hand, if the defense presents evidence that there's no value, there's no economic value as to the 2 chickens were taken, I think that opens the door for rebuttal testimony from Mr. Sutton. So, we'll see how that plays out, but it's excluded from the people's case in chief.
I will understood, put in noted in my office. People are still going to be raising an objection for the record.
Having said that, though, whatever evidence you have needs to be disclosed.
I have
already disclosed that, right?
I have just attempted to disclose it in every means I can. I was unaware that the defense did not have any form of, any means to read a disc. That is standard way in my office provides video and audio recordings if email is unavailable. But I have provided that to the defense, and I have yesterday after, or we had attempted to previously send these recordings by email.
Your Honor, if I could just clarify the ruling, because this is an accounting expert and we call it an animal welfare expert, I would just ask, and I think this is the law, that any rebuttal testimony only relate to the evidence that's presented in direct, in our case in chief. So,
Well, that's what a rebuttal testimony is.
of course, so I don't even know what this witness could possibly testify about in rebuttal because they're an accounting expert and we're testifying on animal welfare.
Well,
But-
it's subject to, at that point, it's foundational issues, I suppose. So,
Okay.
issues, objections regarding foundations at that point.
Okay, thank you, Your Honor.
Okay. Anything else?
There's a couple.
Have we exhausted all your motions and everything?
No.
I wish.
No.
I think maybe now would be a good time, if I could request maybe a 5-minute break.
Yeah, let's take a 10-minute recess at this point.
Huh? A little bit.